some of the delegates from District 3. My name is Catherine Kennedy, and today we are going to be going over objections, responses, and hearsay exceptions.
An exciting part about being an attorney is using and challenging objections. When a question isn't proper by legal definitions, the actual question or answer can be objected to and then banned from asking. In the rules of evidence, sample questions are laid out and explained. Hopefully, this video will help clear up any confusion you might have with the different objections and possibly confusing the hearsay rule.
Let's say you ask a question on direct examination, like, the car was speeding? That would be a leading question, meaning that it suggests an answer of yes. To rephrase the question, you can ask a broader, which car was speeding? Or, what did you think about the red car? Leading questions are objectionable because it is the attorney who is presenting the facts, not the witness.
There are many different ways that the outside of the scope objection can be used. The first one we're going to be looking at is outside of the scope of the case problem. For example, if you had a witness who said, I really like dogs in their affidavit, but on stand they said, I am a certified professional dog trainer, then that would be outside of the scope of the case problem. Basically, a witness is creating a fact that is not included in their affidavit. Outside of the scope of the witness's expertise means that a witness, whether they be an expert witness or a lay witness, cannot testify outside of their qualifications. For example, a police officer could not testify to a medical definition or a medical procedure. Since he is not a doctor, he's only a police officer. Our last scope objection is outside of the scope of an examination. Basically, when you're doing a redirect or a recross, you want to make sure the topics you're talking about have come up before. On redirect, you want to make sure that something came up on cross that you're talking about, and on recross, your topics are limited to what came up on redirect.
Another frequent objection is speculation or lack of personal knowledge. This would come into play if you asked a man, what does your son think of you? Really? This is something only the son could answer. The man couldn't speculate into the mind of his son to see how he really felt. This is also an appropriate objection if the witness wouldn't have any knowledge of the events that happened. If Nick Holt was sleeping while Brad Pitt and Jennifer Lawrence were walking down the street, he couldn't possibly know what happened between Brad and Jennifer. This is a lack of personal knowledge.
Some objections are simple. The narrative objection is used against a question that leads the witness to tell a story without providing an answer. The ambiguous objection is used against a question that is unclear. The compound objection is used against a question that is really two or more questions combined into one.
The one objection that baffles us all, the hearsay objection. Hearsay is an out-of-court statement made by another person. It's gossip. In some cases, though, hearsay is acceptable. Records of regularly conducted business activity is a document and statements within that were produced by a business in a normal manner. An example of that is a police report describing interviews of criminals. The police station probably makes a lot of other reports just like that report. Statements for medical diagnosis or treatment is a statement made for the purposes for medical diagnosis, treatment, or for describing a medical history. An example of this hearsay exception would be if a doctor were describing a medical diagnosis or a medical report. Public records is a document that will always be open to the public. Texas Youth and Government will specify whether a document is public or not. An example of a public record is a police document or a medical report. Presence and impression is a statement made while describing or explaining an event while the declarant was perceiving the event or immediately thereafter. An example of presence and suppression would be if me and my friend Joe were to go to the bank one day and he would be like, hey, what's up? That would be an example of presence and suppression. Excited utterance is a statement made in an event or condition while the declarant was excited or in a state of distress. An example of excited utterance would be if me and my friend Melissa were viewing a building burning down and she were to say, look, the building is burning down.
Objections are fun. You can practice critiquing your own work and then your co-counsel's. For responses, be sure to know the rules of procedure and stand up for your question in confidence. If you're objecting to another team's question, the judge will either go for your objection and say sustained, or against it, saying overruled. More on judging is explained in a different video, but remember to object and respond with conviction. You are right, and the judge should agree with you.